As we've noted elsewhere, under New York law, courts will be far more reluctant to enforce a non-compete provision than they will enforcing a ban against that former employee from pursuing his old company's clients. So what happens when the employer goes too far and pushes for more than they're entitled to? Not surprisingly, the results can be rather bad for the employer. In addition to a company's client base, New York's courts are willing to protect material that is legitimately a trade secret, material that is generally not available to the public. The courts are unlikely going to protect anything that is unduly vague, such as customer goodwill, unless the company can explain why a non-solicitation provision is insufficient to protect their interest. And that's precisely what happened in the recent New York federal court case of Veramark Technologies against Bouk. In that case, Mr. Bouk was Veramark's highest-ranking sales executive, serving as Veramark's senior-most executive point of contact with key customers and channel partners. Bouk wasn't just your average sales guy. His base salary exceeded $150,000, and he also received a substantial commission and bonus compensation, restricted stock awards, stock options, and other employee benefits. When Bouk tendered his written resignation, he made clear that although he was moving to a competitor, he fully intended to honor his non-solicit. In fact, his new employment was contingent on his honoring the non-solicit provision of his agreement with Veramark. But that wasn't good enough for Veramark. Veramark argued that even if Mr. Bouk refrained from soliciting Veramark's customers, the mere fact of his employment by a competitor presented a threat to its goodwill. The court would have none of it, because Veramark couldn't show that this broad restriction on Mr. Bouk's ability to earn a living was necessary to protect Veramark's customer relationships. And therefore, in refusing to bar the defendant from taking a new job with a competitor, the court stated as follows, quote, "Where an employer proffers protecting customer goodwill as the legitimate interest it seeks to protect with a restrictive covenant, the covenant must actually protect that interest. A broad non-compete that baldly prevents competition will not be enforced, particularly where the employer is already protected by a non-solicitation agreement. This is the standard set forth by the New York Court of Appeals in the settlement case of BDO Seidman v. Hirshberg. There, the court explained that a restraint will only be considered reasonable if it is no greater than is required for the protection of the legitimate interest of the employer." The takeaway for an employer here is clear. Don't be a pig. The courts will be less inclined to enforce your agreements. Naturally, if you have any further questions regarding a non-solicit or non-compete provision under New York law, please feel free to pick up the phone and give us a call at 516-791-5700 or toll free at 888-497-3410. This is Jonathan Cooper, and thank you for listening.